35.0511p Code of Criminal Procedure requires that a defendant charged with an offense for which he or she could take DSC be advised by the court of that right. This is generally printed on the citation and often posted in the court.
If you are charged with most traffic offenses, you may be able to require that your charge be dismissed by successfully completing a driving safety course or motorcycle operator training course. If you intend to elect to take DSC, you must inform me when I ask you for your plea.
If the defendant is charged with failure to provide proof of financial responsibility, commonly called no insurance, they must be warned that their driver's license can be revoked for multiple convictions of that offense. Juvenile offenders may need special attention when they appear without counsel. First, it is important to remember the juvenile must appear in person. The offender under 17 must be accompanied by a parent or guardian. The court should admonish the juvenile defendant of his or her continuing obligation to appear in the case and his or her obligation to notify the court of an address change. The court also has an obligation to admonish the juvenile offender about certain expunction rights. After these general admonishments, the judge should have each defendant approach the bench. The court should make sure the defendant understood the admonishments. The defendant should then waive the right to counsel or have the case reset. Then the court should advise the defendant of the offense with which they are charged and the range of punishment. Finally, the court should require the defendant to enter a plea.
Mr. Jones, do you understand all of the things I just explained?
Yes, Your Honor.
Do you want to waive your right to counsel, or do you want me to reset the case so that you may hire an attorney?
I think that I have some questions for an attorney.
Fine. I am resetting your case in 2 weeks. Please return at that time or have an attorney appear for you before that time. See the clerk for a resetting notice on your way out.
Thank you, Your Honor.
Mrs. Garcia, please approach. Mrs. Garcia, do you understand all of the things I just explained?
Yes, Your Honor, but when the officer stopped me...
Mrs. Garcia, I am prohibited from discussing your case until you have entered a plea. Do you understand?
Yes.
Do you want to waive your right to counsel, or would you like for me to reset your case for a later date so that you may hire an attorney?
I do not want an attorney.
Fine. You are charged with the offense of theft under $50. You may be fined up to $500 and court cost. Do you understand the charge and the possible consequences?
Yes.
How do you plead on the charge? Not guilty, guilty, or no contest?
Not guilty.
Do you want a jury trial, or do you wish to waive a jury trial and have a trial before me as a judge?
I would like a jury trial.
Fine. I have entered your plea. Please see the clerk for a setting notice and a pretrial hearing and a jury trial setting.
Thank you.
After entering a plea, the defendant must waive a jury trial if the plea is guilty or no contest, or elect between a jury and bench trial if the plea is not guilty. If the defendant refuses to plead, a plea of not guilty must be entered. Likewise, if the defendant fails to elect or does not waive a jury trial must be set. Notice also that the judge limited any ex parte or one-sided communications. Before the defendant enters a guilty or no contest plea, the court may not ethically discuss the facts of the case with the defendant or anyone else.
Ms. Brooks, please approach. Ms. Brooks, do you understand all of the things I just explained?
Yes, ma'am.
Do you wish to waive your right to counsel, or do you want me to reset your case for a later date so that you may hire an attorney?
I'll go on my own.
You are charged with speeding. The citation indicates you were going 75 in a 55. If found guilty, you may be fined up to $200 and court costs. Do you understand the charge and the possible consequences?
Yes, ma'am.
How do you plead on the charge? Not guilty, guilty, or no contest?
I plead guilty, but I may have some problems paying.
We can discuss paying the fine in a moment. First, by pleading guilty, you are waiving a jury trial and the filing of a complaint. Is that what you want?
Yes, ma'am.
I'm going to ask you to sign this waiver of jury trial and plea of guilty. Are you making this plea of your own free will because you are guilty and for no other reason?
Yes, ma'am.
Thank you. I accept your plea and find you guilty of speeding. I assess your fine at $75 in court costs.
Notice that the judge obtains a written plea and written waiver of jury as required by the law and has the defendant waive a complaint. determines the voluntariness of the plea and accepts the plea. Finally, the judge imposes a fine. The court could also place the defendant on deferred disposition at this point. Pleas of no contest should be handled similarly. Ms. Brooks has raised the final challenge most courts encounter when dealing with pro se defendants, the issue of indigents. The U.S. Supreme Court held in Tate v. Short that a defendant's 14th Amendment right to equal protection of the law was violated by a Texas scheme of pay or lay. In other words, people who could not pay fines could not be placed in jail to discharge fines they were unable to pay. Texas law was changed to include several alternatives the court could employ when a defendant was unable to pay the fine. But before we can reach the issue of alternatives, the court must determine the defendant's ability to pay. The defendant should provide written and sworn information on their financial resources.
Ms. Brooks, please raise your right hand. Do you swear that the information in this financial resource questionnaire is true and correct under penalty of perjury?
I swear.
The court now has several options based on what the court determines the defendant's resources are. First, the court can order the whole fine and cost be paid immediately, can order the fine be paid at a later date, or may order the fine be paid in installments. Some defendants will simply never be able to pay. In those instances, the court must provide the alternative of community service. The defendant discharges not less than $50 of the fine and cost for each 8 hours spent in community service. Let's watch as the judge demonstrates 3 alternative ways for the defendant to discharge the judgment.
I find that you can pay an amount of $145 today.
Or the judge could.
I find that you can pay $30 today and the remainder in 30 days.
Or the judge could.
I find that you cannot pay the fine, but I'm going to order that you complete 24 hours of community service in order to discharge $145 in fine and cost. Please see the clerk for instructions and a community service form.
Finally, the court may find that the defendant is indigent and that community service would work an undue hardship on the defendant. In such an instance, if the defendant defaults in payment of the fine, the judge may waive the fine and costs. Next, you will see the judge order the defendant to pay the fine immediately. Because the defendant is unable to pay immediately, the defendant is in default. Now the judge can proceed to determine the other factors, allowing her to waive the fine and costs.
I'm going to order payment of $145 today, but I'm going to find that you are unable to pay that amount and that ordering community service would place an undue hardship upon you. Therefore, I am waiving the fine and cost. You are free to go.
Courts should take full advantage to giving meaning to their sentences and to protect those legitimately unable to pay their fines. It is critical that all sentences be reduced to writing. Court staff have an equal duty to treat pro se defendants with dignity and patience. They also have an equal duty to refrain from giving legal advice or influencing pro se defendants' choices. Municipal judges have a constitutional and ethical duty to protect the rights of those that come before them. Municipal judges, like all judges, are compelled by the canons of judicial conduct to treat all defendants with patience and dignity, as well as maintaining decorum in their courts. Municipal courts are especially challenged by the huge number of pro se defendants. More citizens will find themselves as defendants in municipal courts than in any other court in Texas. A great number of them will experience this without legal counsel. This places a large burden on the municipal judge to protect the defendant without stepping outside of the judge's role of neutral fact finder and referee.